Good evening, everyone. This is Veer Maheshwar Charitable Trust Latur MS India organizing daily international webinar series. This series is running from last 5 years under the Women Empowerment Mission. Speakers are invited from India and abroad, and they are delivering their topics related to their expertise. The topics related to education, law, health, environmental science, technology, all topics are accepted here. Today, we have invited Mrs. Anjali Mishra ma'am, who is assistant professor at Sarala Birla University, Ranchi, Jharkhand, and the topic is intellectual property rights. I welcome you, ma'am, from my organization and from all the participants, those who are joined here. This intellectual property rights is topic is important for all academicians to create their intellectual property, to think innovatively. So what are the different aspects of intellectual property rights related to our academians? She will explain in the next few minutes, in the session. I welcome you, ma'am, again, and I request you can start your speech now. Thank you.
Thank you so much, sir, for providing me the opportunity. And I am Anjali Mishra, currently serving as an assistant professor in the Department of Pharmacy, Sarala Birla University. When sir asked me to talk on something that interests me, even though I am a pharmacy professor or assistant professor rather, I would say, but the topic that always excites me is intellectual property rights. Like law has a special niche to talk about when it comes to my interest. So today I will be talking and delivering a speech on intellectual property rights. I'll share my screen first. So please let me know if the screen is visible.
Yes, ma'am. Yes, ma'am. Screen is visible.
Okay. Thank you, sir. So to begin with, intellectual property rights. Now, when we talk about property, we know what is property. Property is something that we own as an individual. Property which we see around us, like land, any sort of jewelry, that's a tangible property. But what property we are going to talk here is something that is we cannot see. It's something which is a creation of our mind. So that comes under intangible property. And we are going to talk in detail about the intangible property or the property that arises because of one's intellectual thoughts and ideas. So in the next few minutes, we are going to cover about...
You can reshare, ma'am. Again, it is hidden.
Okay, sir, I'll reshare. Sir, is it visible now?
Yes.
Okay, sir. So as I was talking, we will be discussing in detail about what initially led to the foundation of IPR, then a basic global ecosystem of IPR. Then we will be also focusing on the implementation of IPR in India and the core aspects of IPR that we generally study when we talk about IPR, that is patent, copyright, trademark, industrial design, trade secrets, geographical indication, and many more. We will also see that how actually technology transfer and commercialization of things, right from ideas to actual making it implement to the common masses, how does it take place? We are going to see that as well. And later on, how actually IPR is enforced publicly. We are going to see that as well. So this is a basic roadmap of today's webinar. Moving ahead. We always talk about why should one get an exclusive right over their ideas. I'll just give a simple example that if I own an apple, I can also eat, and a person who is next to me, I can share that apple with that person. So apple is something which is available widely. However, if there is something which is a creation of my own ideas, own thoughts, own knowledge. I can teach other person related to that. However, I cannot pass something to that particular person. So something which is created by a particular person because of his or her intelligence should get some profit out of it. So I believe something which is created because of somebody's idea, somebody's knowledge, must get some sort of reward for that. So that is why exclusive right must be handed over to a person who is responsible for generation of any sort of intellectual property. So there are so many theories that is responsible for supporting this idea that why exclusive right is to be given to a particular person. Theory is an incentive theory. If a person is responsible for discovering or delivering something that will help the masses or the individual or the community, then that person must be rewarded, because reward creates a sense of satisfaction in oneself, and reward also encourages one person to look for some more ideas, to do something more for the society. So incentive theory supports that if a reward is provided to a particular person, when the person has looked for something which will help the community, so if a reward is given to the person by giving him some sort of exclusive rights over the foundation, so that will help in making more discoveries in future. So that supports the intense incentive theory. Moving on to the next theory, that is natural rights view. When we look at giving fruits to a particular person's share, so if a person has done something, that person must be rewarded with certain kind of fruits or certain kinds of moral claim. So that is what is supported by natural rights view. Apart from that, when a person or when a or when a when an individual is responsible for presenting something new to the society accepts it with open arms. And in exchange to that, that person who has found something great, they give him or her certain kind of reward. So that is also another theory that supports giving exclusive rights to an individual. That is bargaining sort of things happen. So if an individual provides something to the society in returns acknowledges the person, rewards the person, as well as applauds the person for his or her discovery. So that is another theory that supports this statement. Further, when it comes to some sort of intellectual property rights like trademarks or industrial designs or logo, it actually helps in product identification. And eventually, when a product is identified by its consumers or customers, the type of product or the quality of the product becomes non-negotiable. For example, if we go to market to buy certain brands of shoes or certain brands of spectacles, we choose certain brands over another local because those branded materials ensures quality. So basically, I believe that granting exclusive rights to any sort of intellectual property helps in ensuring the quality of the product as well, and easy identification of the product also happens. Apart from that, one last theory that supports this statement is dynamic efficiency. Basically, IP helps to establish an efficiency between good quality and bad quality of products. Thus, if quality is kept at the optimum level, more and more invention will come in future supporting these ideas. So there are so many theories that have supported to grant exclusive rights over ideas because it will help in future invention, in future innovation. So these are some of the things that helps us to understand that why granting exclusive rights to anybody's intellectual property is vital. Moving ahead, as we are aware of the basic scenario of intellectual property handling in India, but going back a little more, let us understand that what initially led to the presentation of IPR globally. Globally, if we talk, when we talk about United Nation is a body that looks over the matter related to everything all over the globe, all over the world. So we have different organization under United Nations that looks after various aspects. For example, when it comes to monetary aspects, we have International Monetary Fund. When it comes to some social aspects, we have UNESCO. Sorry. When it comes to something regarding women and maternal health, we have UNICEF. Similarly, when we talk about intellectual property rights, I'm so sorry, we have WIPO, World Intellectual Property Organization, which comes under World Trade Organization. So these are the bodies that works internationally to help establish an international intellectual property relation between two or more than two countries. In the right hand side of the slide, we can see some of the patent offices, like we are aware, Indian Patent Office, which is located in Kolkata. Apart from that, we have United States Patent Office, we have European Union Patent Office, we have Japan Patent Office, CNIPA is the Patent Office of China, UK International Patent Office, DPMA is the Patent Office of Germany, and INPI is the Patent Office of France. So in the right hand side, we are seeing the international intellectual property offices that occurs at national level. Whereas on the left hand side, we are saying the organizations that helps in the global recognitions of patents occurring in these national levels. We are going to see these in detail in the coming slide. So basically, when we talk about protection of intellectual property is not merely only for the national protection. It applies internationally as well. Because if we discover something, if we make any invention in a particular area, it is not necessary that the other area may not have similar invention. There may be possibility that the other area might also have the similar invention. So there may be clashes of invention, or sometimes infringement of patent also happens. So in order to protect somebody's intellectual property, the WIPO or the World Trade Organization has come into picture. Let us have a little basic idea about WIPO. World Intellectual Property Organization has its headquarters in Geneva, Switzerland. It was established in 1967. And as I already spoken, it is a specialized United Nations agencies, and currently it has 193 members. And India is also a part of this important organization, but it joined in 1995. Most probably, India started following the WIPO most frequently after the TRIPS agreement, which we are going to see now, after 2005. Basically, WIPO was a boon for all over the countries worldwide. Because if WIPO did not existed, there might be various clashes among two different countries over a single discovery. So main functions of World Intellectual Property Organization is to consider all the treaties and to come at a single judgment. A very important cooperation system was also invented by WIPO, which is called as PCT, that is Patent Cooperation Treaty. Under this treaty, you need not to register multiple patents in various countries. We have one single platform where we can register patent, and that patent will be applicable to various other countries. Apart from that, when we file a patent, a period of 12 months is given to is taken by the government to analyze whether this patent is novel, whether this patent is exclusive, and whether this patent has not been discovered prior, and whether it is of use or not. So these all databases are already present with the World Intellectual Property Organization. So that helps in identification and easy grant of patent, and it also helps to understand or to eradicate any patent infringement in future. Apart from that, any dispute resolution, any cases of patent dispute, any cases of patent infringement may also be brought up in World Intellectual Property Organization. And this is a forum where two countries or more than two countries that do not come up with a solution over a particular discovery may reach to WIPO for their resolution. Moving ahead, under WIPO, we have so many treaties. As I've already discussed in the previous slide, there it was Patent Cooperation Treaty, where if I discover something in India on 30th of July, that is today's date, I may not go to another country and again re-register the patent. What happens when I keep on re-registering my patent in multiple countries? First of all, the cost enhances, the cost of the product, main product increases. Second of all, it wastes up time. And during the time wastage, there may be possibility that some other person might copy my patent and that patent might get published in another country. So I may not enjoy my remuneration to the fullest. So when we talk about patent cooperation treaty, in this treaty, one person who has discovered something new and something useful for the mankind, novel, may register under patent cooperation treaty, one at a time. And apart from patent cooperation treaty, WIPO also have 25 another international treaty, which include Madrid Treaty. Madrid Treaty was the first treaty which also considered trademark registration as a vital intellectual property, because trademark is something which helps to identify a particular type of registration. It helps to identify a particular type of product. So not only patent, we under intellectual property rights, trademark also has a vital role. Now, when we talk about Hague system, Hague Treaty, here industrial designs was also considered as a part of intellectual property. Under Berne Convention, here the basic or copyright treatment was also considered. The copyright can be anything, any sort of recreational, like any songs, any music videos, any movies, or any sort of written things, which is a production of somebody's intellectual thoughts. So that was also considered under Berne Convention. So now when we talk about something new that has come into market, that is digital era copyright norms. As we know, when we are on YouTube, when we listen any songs and that songs belongs to a particular publisher, we cannot play that song because we might get copyright issues. We cannot use anybody's else photo without permission. We may get copyright issues. So not only patent, when we see all these type of treaties or systems, we also consider that not only the patent, but trademark, industrial design, copyright, then e-copyrights things are also considered as a vital part of international treaties globally. Something that is very common to India when we talk about intellectual property is the geographical indication. Geographical indication helps to identify a particular area with something that is very famous or local to that place. For example, we know that Banaras, Varanasi is famous for its particular type of sari. Kanjipuram is famous for its particular type of saris. And Alfonso mango, we get very popular Alfonso mango in Ratnagiri in Maharashtra. For example, a particular type of lychee is very popular in Muzaffarpur. And so these are some of the things that are also considered as a part of intellectual property. So various treaties have come up with certain kinds of intellectual property. However, it is slightly deviating from the term intellectual property, but it has now found a place in intellectual property. One important treaty which I would like to put here is the Budapest Treaty. In this treaty, when a particular scientist is working on a particular microorganism, that microorganism need to be specified in the patent filing process. So here, the best part of the Budapest Treaty was you need not to file another patent because we have microorganism involved, and microorganism is not it's not something that we have invented. It is something which is already present in the nature. So here the Budapest Treaty says that when there is any microorganism involved in the discovery of something new, for example, a particular microorganism is involved in discovery of particular antibiotic. So here there is no need to file another patent. We can, under the Budapest Treaty, we can have a single patent where we can disclose the type of microorganism. So that was the best part of the various treaties which was signed under World Intellectual Property Organization. All the treaties that have come here have just come here to make our life easy, rather than going to each and every country's international intellectual intellectual property right organization and investing money and waiting for a longer period of time, because filing a patent, getting it published, rechecking it takes roughly, if I just talk roughly, takes around 2 to 5 years of time. So when we are saved by these treaties, it saves our time, it makes our work more reliable. So that is the beauty of these international treaties that WIPO has come up with. Another a very important basically trade secrets of intellectual property right, that is TRIPS, trade related aspects of intellectual property rights, have also proven a boon for the countries who have become a part of the World Trade Organization. The countries who are a part of World Trade Organization have now started taking the benefits, because various countries before the arrival of TRIPS had different types of standards for their intellectual property. Some countries made the protection of intellectual property for 5 years, some made it for 10 years, some it for 15 years. So what happened? There were clashes occurring globally and internationally. As well as, if I talk about India, we were following only the process patent things before TRIPS came into picture. After India adopted the TRIPS in 2005, we started considering process patent and product patent both. So TRIPS was a basic boon for us. After the arrival of TRIPS in India, we have considered granting of 20 years patent protection right to an inventor right from the date of filing. Apart from that, all the patent which were registered under TRIPS and WTO was made globally. So a person who is making discovery in any nook and corner of the globe will have acknowledgement everywhere, all over the globe. So it also helps to settle the dispute settlement if any arises. So TRIPS was definitely a boon for all of us. We already have spoken a lot about these 25 treaties, which was a basic boon when we talk about following the intellectual property rules and regulation globally. Here I would like to point out one very important treaty, that was Marrakesh Treaty. Marrakesh Treaty came up with an idea for making things available for underprivileged people. For example, if a book is available online, offline, but that book is not available for a person who is visually impaired. So any person who is challenged because of some or the other reasons, why they should be devoid of any sort of benefit. So under Marrakesh Treaty, the access to publicly put all those things which was available online in Braille language, because Braille language is a language which is being studied by people who are visually challenged. So this treaty gave them the liberty to publish whatever material is present to visually impaired students or the person who is willing to go through the things which is available after 2030. So basically, this is a clear picture that after United Nation bought WIPO, that is World Intellectual Property Organization, various national laws across the country started following WIPO, World Trade Organization, and this TRIPS has made everybody's life easy. It has stopped the dispute arising globally. So, as I'm from pharmaceutical field, my interest lies basically more on the pharmaceutical sector. So, when I talk a picture which was before TRIPS and when I talk about pictures after TRIPS, pharmaceutical industries have shaped drastically. As I already said, India was not following TRIPS before 2005 and we were only considering the process patent. So, for example, if any pharmaceutical company was manufacturing by X process, any another country would modify that process and make it through Y process, and that could also have been patented. So, India was also following this. But after 2005, when we started considering product patent also, more inventions started happening in pharmaceutical sector. Initially, we were only considering generic medicines. Now we started investment. Our government started investing more into the pharmaceutical field, and that actually encouraged the native pharmaceutical sectors to bloom. Now we can proudly say that we are the third largest generic producer and seller in our globe. Because of these sort of protection to our patent, or after the expiry of patent, the joy of having that ANDA filing process, that has also proven a boom after the TRIPS agreement. So now, even though we are talking about granting exclusive rights to people who actually look for who actually are responsible for the development of any novel invention, we also are on a page where we want to make medicines affordable to each and every person, each and every classes of people. So that is the reason patent grants exclusive rights, but only for a certain period of time. And that period roughly, or if I talk broadly, ranges for 20 years. After the expiry of the patent of after 20 years, that becomes clearly available for masses. And we, when I talk about Dr. Reddy's, a very major pharmaceutical industry of India that is very famous in working on these after the expiry of patent, they're very expert in working on the expired patent and filing ANDA process. So this is what I've already spoken, that in 1995, India has joined World Trade Organization. We have made our first patent amendment, even though we got our first Patent Act in 1970, but there were so many amendments which were happening after so many globally. There were so many changes happening globally when it comes to World Trade Organization or after TRIPS occurrence. So finally, in 2005, we adopted TRIPS. We started considering product patent as well. So, as I've already said this as well, Patent Cooperation Treaty helps an individual residing in any part of the world to register his or her patent internationally. You need not to go at each and every country's intellectual property offices and fill the forms, wait for the scrutiny period, then get your patent get published, wait for any infringement, and then finally get it granted. So that time is basically saved. Now, when I talk about India's patent filing process, right from day one, when we file a patent, up to 12 months, that patent is under scrutiny, or basically it takes a 12-month of periods. So after 12 months, we look for investors, we look for so many things. PCT give us a time of 30 to 31 months, which is more than or double than your normal filing process. What is the advantage of this large time? Under this time, we may accumulate investors for large scale production, for technology transfer, or we may also wait for various kind of grants receiving for in order to make it larger. So that is the best part of patent cooperation treaty. And as I've already spoken, the major advantage of patent cooperation treaty is you don't have to go and to every country's offices. You can do a single filing. Apart from that, we have a deferred cost. We get usually the cost is also minimalized, and we get a period of 30 to 31 months in our hand to accumulate investors, to think about technology transfer. Apart from that, we have informed decision consent. We can look for investors, and then we can also look for priority reservation. For example, we are not sure about what exactly we are going to patent. We can still put it under PCT and reserve it for a certain period of time. What if it gets neglected in the later stage? That's a different thing. But we can still file if we think it is novel and nothing has been discovered. We can still get that additional point of priority preservation. And then we can definitely have a strategic flexibility to obtain an interim report or to look for any other larger manufacturers. So here are some of the pharma companies which I've listed here. When we see that we need to protect our patent, we just think that no, I have invented something, I am a discoverer of something, and I want to protect it. But pharma companies think way beyond that. They have not only protected a particular patent, because that might get expired in 20 years, then it may undergo generic things. Now imagine a scientist, a company, a huge people who are involved behind a single molecule may lose the rights after 20 years. So what the pharma companies which I've listed here is Pfizer, Roche, Novartis, Merck, Moderna, Sun Pharma, and Dr. Reddy's. They have modified patent strategy. For example, Pfizer has made a very popular COVID vaccine. Now, rather than protecting the vaccine or the process or the product, they have protected the entire platform. For example, mRNA technology was used in order to modify, in order to make that medication or the vaccine. So they have patented the entire platform. So this will help in maintaining Pfizer the dominant production of mRNA vaccine globally. So they can earn the rights even after the patent has expired 20 years, because now they had layered the patent protection. They have not just protected their main product, but they have also protected the multiple layers, which has helped in manufacturing of that particular product. Apart from that, protecting single patent helps in protecting a single product. But if you protect multiple patents which are related to a particular product, that is called as secondary patents. And this also helps in enjoying the rights for a longer period of time. Here I would like to point out a case which is actually continuously going on regarding Novartis and Supreme Court of India. Here, Novartis modified a slight molecule in an anti-cancerous drug and tried to patent it. But a litigation was filed against Novartis, and this case is under judiciary yet, because the law says that slight modification of any molecule which is currently used may not give you the rights to get it patented and enjoy the full rights. However, the pharma companies are going beyond the normal patenting process, and they are fencing also, just like the Merck and company has done. They have fenced their patents through various platforms. Moderna has also patented the mRNA technology, which was used in product, which Biotechnica vaccine, which was used very popularly in COVID. Sun Pharma actually has not patented the product or the process. In fact, it has patented the duration of particular drug. For example, if a company is making X drug and that X drug has to be taken thrice a day, what Sun Pharma has done, instead of taking a particular drug thrice a day, they have modified the excipient, they have modified the formulation and made sure that thrice a drug which is taken thrice a day should be taken only once a day by a patient. What will happen? The patient will be not tired of taking the medication again and again. So this is a basically slight modification of excipients. See, IPR does not ask you or ask anybody to make anything which is like something out of the box, something which is very challenging. As patent, IPR must be simple. It must be used by anybody, everybody. It should serve to mankind. That is the basic need of any intellectual property rights. And if that is met, definitely an intellectual property right is granted. As I've already spoken, Dr. Reddy's is famous for entering into the generic market. And that is why, be it Dr. Reddy's, be it various pharmaceutical giants like IPCA, we are at the forefront of generics in world and globally. So rather than thinking straightforward regarding intellectual property rights, these companies have come up with slight modification of the patent strategy, and thus it helped them to enjoy their rights for a longer period of time. Even though by ethically and by law, the patent expires in 20 years. But still, when they have layered the patent, when they have fenced the patent, when they have layered protected the entire platform, they have enjoyed the rights even for like 50 years, even for more than that. So this is something that we have a basic idea about what exactly is patent and for how many years a patent's right has been given. Copyright is something which is related to literary work, music works, drama works, and this duration is for slightly more than patent. Trademarks helps to identify a particular product, a particular company. Industrial design is something which helps in easy identification of the product. Trade secrets, obviously, this is something very secret, and I don't think there is any expiry to this trade secret unless it is disclosed and made in public. And I've already spoken geographical indication, even though this is not something result of somebody's thought process, but still this represents the originality of any particular place. That is why it is also a core aspect of intellectual property rights. Now, when we have spoken a lot about intellectual property rights, enforcing intellectual property rights is a really challenging for law protectors. Because if somebody knowingly or unknowingly infringes any patent, what if a patent inventor does not know about it? Then it might happen that a discoverer might only get a certain share of profit, might not get entire discovery's benefit. So that is something very happening to the original inventor. So such things, piracy, any infringement must be brought to the notice, to the court, to the law, and thus India's law states that if a infringement is proven, then the person who has infringed will get all sort of remedy, will get all sort of help from the law. Apart from that, any or if a infringement is proved, then fines and judiciary actions will be will be taken against a person who has infringed the patents. Apart from that, any unethical product entering a particular border, claiming that this is a discovery for any particular product, will have suspension right at the border. Apart from that, we do have any all or any other alternative platforms where the lawmakers, the lawsuits help to actually enforce intellectual property rights on scale, actually on proper scale. Now, when we are in an era where we use AI almost every day, so actually protecting intellectual property has become a huge challenge for us, because AI can make anything now. Now AI can make music, AI can make AI drawings, AI can make any photos, AI can merge two people who are at different positions, who are at different places. So actually, AI has challenged, because when IPR came into picture, AI was not there. But now AI has mainly challenged, and it has made intellectual property people who are inventors their job very difficult. So using AI or thinking where AI is being used, is it is used ethically or not, is a big challenge. And rational thinking has to be done when we are using AI generated works. And using somebody else's work, slightly modifying it using AI, is also not ethically correct, because these things are something which will harm the inventor's perspective, which will harm the inventor's lifelong creation, and that is not something which we are talking since a very long time, because intellectual property is a person's own creation, person's own idea, and a person who generates these ideas, these creation, must be rewarded. Apart from that, when we talk about digital platforms, be it YouTube, be it various other platforms as well, we have certain good things about them, that if we use anybody's photographs, if we use anybody's music, we might get copyright strike, and then we have to take those things down which we are using somebody's else. We might use somebody's else work, but with proper credit, because YouTube is something which is available publicly, and using somebody else's work because that is available in public domain can be done, but proper credit must be given to a particular person whose work is originally that. Apart from that, some things which are very essential, and for example, when we talk about corona era, even though the patent was granted to the various companies who had invested crores and money's efforts in finding a particular vaccine, patents were given to them. However, at that era, the medication was an essential part for the masses. So various government, various NGOs came up with the ideas of providing free medications to common masses, because that was a essential part of that time. If at that time intellectual property rights is given to a particular organization, because the whole point of giving intellectual property is benefiting the person who is inventor, as well as giving helping the masses. The whole idea of invention is that helping humankind. But at that era, which was very crucial, people were dying, there were epidemic. So how could a government, or how could any rights grant exclusive when common mass is suffering? So anything which is very essential, cannot be afforded by common mass, must be made available under various law. Apart from that, as we have already spoken about, access to medication must have actually, for that purpose, we must create TRIPS agreement. We must look after everything. However, if we make everything access to common masses, that would also discourage inventors, and then we will not get many discoveries in future. Hence, access to medication, affordability must be considered. And apart from that, we must also focus on green technology. We must also talk about climate preservation, considering everything. And thus, these are some of the contemporary challenges and debates which which actually are challenging when we talk about IP rights. So we have spoken a lot since past few minutes. Here we have just come up with summary that IP is, even though IP is something an individual's idea, individual's creation, but its right is something which should be recognized globally. And that has been possible with the help of World Trade Organization, TRIPS framework, and WIPO treaties. WIPO has made an inventor's life very easy, as well as it has also protected the Section 3D of TRIPS agreement, which states that any person, any company cannot reapply patent again and again, which is called as evergreen technology. Because evergreen technology, if it happens again and again, it will stop or it will discourage the common masses from using a particular product, because patent makes any product, any process expensive, and thus its affordability becomes a question mark. So TRIPS agreement also helps to point out the Section 3D of India's Patent Act. As we've already spoken, PCT has saved time, information, cost, and that's a boon for any inventor. Various pharma companies have also modified IP strategy and have enjoyed IP rights for a longer duration of time. So I think I have spoken a lot about Indian intellectual property rights. And if any questions, I'm open to questions.
Thank you, ma'am. It was great to listen on this topic, intellectual property rights, how PCT is useful to all, how AI is affecting on our intellectual property, what are the different things of the intellectual property, the law related, all these things. So we get this knowledge today. They can unmute. Mr. David Singh.
जी सभी को नमस्ते। नमस्ते मैडम, नमस्ते।
नमस्ते।
आवाज आ रही मैडम?
जी सर, आपकी आवाज आ रही है।
मैडम मेरे एक तो धन्यवाद देना चाहूँगा कि आज इसकी जरूरत है समाज को, ऐसे व्यक्तियों की, क्योंकि इसकी नॉलेज होना हर किसी के लिए आवश्यक है आज के भागदौड़ में। मैडम मेरे दो सवाल होंगे। पहला ये सवाल है कि अगर मैंने कोई एक पुस्तक लिखता हूँ मैं, और मैं उसको रजिस्टर्ड पेटेंट नहीं कराता और उसको आप पब्लिश करा लेती है अपने नाम से, तो उसका क्या, कैसे मैं उस तक पहुँचूंगा, कैसे मैं उसके लिए लड़ सकता हूँ कि ये मेरी पुस्तक थी। दूसरा सवाल मेरा ये है कि मैंने आपका उपन्यास लिया, उसका टाइटल बदल दिया, सिर्फ कैरेक्टर बदल दिए मैंने, बाकी कुछ नहीं बदला, सिर्फ जो उसके पात्र थे वे बदल दिए मैंने, और अपने नाम से पेटेंट हो जाएगा क्या या नहीं करा लिया?
थैंक यू फॉर द क्वेश्चन सर। जैसे कि आपका पहला सवाल था कि मतलब अगर आपका पुस्तक किसी और ने छाप दिया और तो आप उसके अगेंस्ट कैसे जा सकते हैं। तो सर हमारा जो लॉ है वो हमें परमिशन देता है कि पहले आपको प्रूव करना पड़ता है कि क्या आपका पेटेंट ओरिजिनल आपका आइडिया था, वो कब था, आपको क्रोनोलॉजिकली प्रूव करना पड़ता है। अगर बाय लॉ वो प्रूव हो जाता है कि ये आपका आइडिया था और किसी ने ये आइडिया चुराया है, तो बेसिकली पेटेंट का इन्फ्रिंजमेंट हुआ है, तो और ये प्रूव हो चुका अगर लॉ में, तो आपको हर तरीके की रेम्यूनरेशन, हर तरीके की सहायता, चाहे वो आपके कोर्ट केस से लड़ने की वजह से हो या कोई भी तरीके का सहायता, आपको जितना मॉनेटरी नुकसान हुआ हो, वो सारा का सारा आपको सामने वाली पार्टी जिन्होंने आपका पेटेंट इन्फ्रिंज किया है वो करेगा या वो करेगी। और अगर आपका दूसरा सवाल है सर, जैसे कि हम किसी और का काम को थोड़ा सा मॉडिफाई करके हम अपना काम कर ले, तो सर ये हमारे पहले क्वेश्चन का ही कॉन्ट्राडिक्शन हो जाएगा कि हमें किसी और का काम नहीं करना है। यही तो है सर, एथिक्स की बात है। हमें किसी और के काम को अपना काम बताना ही नहीं है।
मैडम ये सही कहा आपने, लेकिन जो ऐसी चीजें करते हैं वो शिक्षित लोग ही करते हैं। ये भी है, कोई अनपढ़ तो नहीं करता, क्योंकि मैंने देखा है कि मैं उन कवि का नाम भूल गया, उनकी कविता को एक प्रोफेसर ने एक प्रतियोगिता में प्रस्तुत कर दिया और उन्होंने प्रथम प्राइज भी प्राप्त कर लिया। फिर किसी मैडम ने वो फेसबुक पर पढ़ा था कोरोना के टाइम, फिर वो लेके आई और उसके बाद में विवाद बढ़ता चले गया। तो ये तो सही कह रही है मैडम कि करना ही नहीं चाहिए, ये तो नैतिकता की बात आ जाती है। लेकिन समाज में सब तरह के लोग रहते हैं और शिक्षित ही होते हैं। अभी देखो, अगर नीट की बात करते हैं तो वे प्रोफेसर ही थे, गुरु थे हमारे, जिन्होंने और खरीदने वाले भी माँ बाप ही थे पेपर। तो ये तो नैतिकता की बात हो जाती है मैडम कि, लेकिन क्या ऐसा करने से पेटेंट हो जाएगा कि मैं आपके पात्र के नाम बदल के और उसका रजिस्ट्रेशन करा लूं, पेटेंट करा लूं, तो क्या वो हो सकता है कि?
सर जैसे अगर हम कोई चीज को भी पेटेंट कराते हैं तो जैसे फर्स्ट डे है वो होता है पेटेंट फाइलिंग डे। इससे 12 महीने तक आपका पेटेंट जो है वो पब्लिश होने टाइम लग जाता है। 12 महीने से 18 महीने से समय लगता है पब्लिकली आने में। एक बार जब वो पब्लिकली आ जाता है सर, उस प्रोसेस को हम लोग बोलते हैं पेटेंट हैज बीन पब्लिश्ड बट नॉट ग्रांटेड। तो पब्लिश होने के बाद सर उसको कुछ समय दिया जाता है। अगर उसको कोई इंसान क्रॉस करता है कि नहीं ये तो मेरा काम है, अगर वो, क्योंकि अब वो पब्लिक डोमेन में है, और अगर इसके अगेंस्ट कोई जाता है कि दिस इज माय वर्क, दिस इज माय प्रोडक्ट, दिस इज समथिंग विच इज रिलेटेड टू मी, तो ये समय पे उसकी फिर जांच होगी। और अगर ऐसा पाया जाता है सर तो वो बैक टू डे 1 चला जाएगा। फिर अब वो आगे जाके पब्लिश नहीं होगा, इसीलिए सर वो पब्लिक डोमेन में आ जाता है।
जी धन्यवाद मैडम।
थैंक यू सो मच सर।
धन्यवाद जी, अच्छा क्वेश्चन, क्योंकि हमेशा होता है मैडम जी दिया है। अभी जो उपस्थित सभी प्रॉपर्टी पेटेंट अभी डॉक्टर साहब शुक्ला सर प्लीज।
Good evening, Dr. BETKAR sir. Good evening, ma'am. Thank you very much for wonderful presentation on the IPR. And you have given a very interesting view of how the international channels and connections are there. So we don't have to run, and rush at every place. But my question is, the law is different on different land. So the law of the land is different at different places. So where this case will stand, if it is an international thing, and how we will how that person will face the problem, where he'll face the problem.
Sir, as you have rightly spoken, that law is different for different areas. But so that is the reason WIPO, World Trade Organization, and TRIPS have come into picture. Because even if a person is enjoying the rights in a particular area or a particular territory, that person might face patent infringement globally. So in order to understand, because discovery might happen, the same kind of discovery might happen in India, in China, in Bangladesh, and unintentionally the discovery might have the same things, the same compound, the same thing. But the chronology or the time of discovery matters the lot. If a person who has discovered for the first time approaches the international body, then the person who is responsible for the primary discovery will get the benefit. For example, sir, we have some well-known patents like Tulsi patent, Neem patent, which Indians did not patented initially because we were not aware. And these patents were done by Western countries. But when we came up when we were made aware that this is something that belonged to us, we fought in the international court, and then we made sure that we get our product or patent back. So that is how, sir, we can go to the international courts, and that is why international courts are made.
Perfect. So I think, we are having a very nice global, IPR system. And nowadays, the patent, when we're talking about, we suppose I'm using some ancient knowledge and I want to patent it, for my use. Suppose I'm using Surya Namaskara for some of my patient, this protocol. So can we patent this or we cannot patent this?
Sir, we cannot patent something which is known to everyone. So because for patent, there are certain things. For example, it should be novel. And secondary, it should be non-obvious. Something that is, we are aware that Surya Namaskar has multiple benefits. So what is something, we are saying something very novel. So it should be completely non-obvious. So the example that you cited here, sir, we cannot patent it.
To improve the cognition level among the school-going children, we are using, the writing skill. We are doing Surya Namaskara, and we are doing, some medications we are giving. So that kind of protocol was there. But can we do it or no?
Sir, as I've already said, that if any research or any new study done because of Surya Namaskar say something different, then we can do it. But the whole idea of Surya Namaskar is known to everyone. That is why we cannot patent this process. Because this is it is not a basic part of non-obviousness, and any patent must be non-obvious.
Yes, thank you very much, ma'am, for your wonderful explanation also. I remember, the Chinese people were using serum, to control the smallpox. And Mr. Edward Jenner has collected the idea and he made vaccine. And he's known to the whole world, Edward Jenner. And he's recognized for this. But basically, the Chinese people have developed this idea, to putting a serum of the suffered patient on the other person and prevent the conditions. So now in this case, also Chinese people can also claim that, the smallpox has been eradicated because of them. Thank you very much, ma'am. Thank you, Dr. BETKAR, sir.
Sir, she has explained so many things from pharmaceutical for. I would like to ask, ma'am, patent expires with. Oh, you are saying that it is multiple layered, it can be enjoyed more than 60 years. So please just shortly you can explain.
Sir, can you please repeat your question, sir?
As a patent or expires within 20 years. If it is medicine or any pharmaceutical, the medicine can be enjoyed 60 years. That was using a layer system which can use the expire more than 50 years.
Sir, that example was of a particular technology. So, for example, Moderna vaccine has made a particular Sputnik vaccine. So, sir, this vaccine they patented, as well as they patented one more thing, which was the technology, the platform which they used to make this medication. So, sir, the patent of the particular vaccine will expire in 20 years because that is what the maximum limit of enjoying patent is. But they have, apart from that, they have also patented the process through which they have made that vaccine. And then that will also expire in another 20 years. So obviously, sir, when they will not disclose the technology, just knowing the product might not help their rivals to make something different. So, sir, that is how a company enjoys patent, not just for 20 years, but even more than that.
Thank you, ma'am. It was something useful topic to all, and we will take benefit of filing the patent to know about the PCT and date of the patents EI. So these things you have explained for all participants. In future also you'll be here on different aspects of the patent for particular point if you want to explain here. Thank you for accepting our invitation and sparing your valuable time in this field. Thank you.
Thank you so much, sir, for providing me the opportunity. Thank you so much.
All participants are in so that you will issue the certificates. Thank you.